what the Supreme Court of the United States has just done in ruling on the question of your phone's location trail, the legal determination that the highest court in the American judicial system has made about the constitutional status, the Fourth Amendment protection, the government access rights, and the privacy expectations that attach to the comprehensive record of your physical movements, your daily routines, your personal associations, your medical appointments, your religious attendance, your political activities, and every other dimension of your private life that your smartphone's location trail documents with a continuity, a precision, and a personal revelatory power that no previous surveillance technology in human history has been capable of generating about ordinary citizens going about their normal daily lives, is a ruling of extraordinary legal significance, extraordinary constitutional consequence, and extraordinary practical importance for every American who carries a smartphone and who has never previously had occasion to consider what their phone's location trail actually reveals about them, who has access to it, under what circumstances that access can be obtained without their knowledge or their consent, and what specific settings changes they can make right now to meaningfully limit the location trail that their phone is continuously generating and storing in ways that this Supreme Court ruling has now made more legally and practically consequential than most Americans have ever had reason to understand. The legal journey that led to this Supreme Court ruling began with the foundational question that the explosive growth of smartphone location data has forced the American legal system to confront, whether the continuous, comprehensive, and involuntary generation of a detailed location trail by a smartphone that its owner carries everywhere they go as an essentially indispensable tool of modern life represents the kind of search that the Fourth Amendment requires law enforcement to obtain a warrant before conducting, or whether the third-party doctrine that the Supreme Court established in earlier decisions involving bank records and telephone call records applies to location data in ways that allow law enforcement to obtain smartphone location trails from wireless carriers and application companies without a warrant and without the knowledge of the person whose movements the data documents. The third-party doctrine, the legal principle established by the Supreme Court in the 1970s, cases of United States v. Miller and Smith v. Maryland, holding that information voluntarily shared with a third party loses Fourth Amendment protection, because the person sharing it assumes the risk that the third party may disclose it to the government, was the primary legal framework through which law enforcement agencies across the United States had been obtaining smartphone location data from wireless carriers and application companies without warrants, arguing that because smartphone users generate location data through their voluntary use of wireless networks and location-enabled applications, they have assumed the risk that the carriers and application companies receiving that data might share it with law enforcement without a warrant, and therefore have no Fourth Amendment reasonable expectation of privacy in that data that would require the government to obtain a warrant before accessing it. The Supreme Court's landmark 2018 decision in Carpenter v. United States began the legal evolution that this most recent ruling continues and extends, holding in that case that the third-party doctrine does not apply to the historical cell site location information that wireless carriers collect from their customers' phones, because the comprehensive nature of cell site location data, its retrospective quality enabling detailed reconstruction of past movements, and the seismic shifts in digital technology that have made carrying a phone a practical necessity rather than a voluntary choice together distinguish it from the more limited and more genuinely voluntary disclosures to which the third-party doctrine was originally applied, requiring law enforcement to obtain a warrant before accessing historical cell site location records from wireless carriers. This most recent Supreme Court ruling extends and refines the Carpenter framework in ways that address the categories of smartphone location data that Carpenter left unresolved, including the GPS-precise location data generated by smartphone applications and stored by the application companies rather than the wireless carriers, who were the subject of Carpenter, the real-time location data sought for ongoing surveillance rather than the historical records at issue in Carpenter, and the location data generated by the growing ecosystem of connected devices, location-enabled applications, and commercial data brokers whose collection and aggregation of smartphone location data has grown dramatically more comprehensive and more commercially widespread in the years since Carpenter was decided. The specific holding of the new Supreme Court ruling and its precise legal boundaries, the exact categories of location data that now require a warrant, the specific standards that warrant applications for location data must meet, the exceptions to the warrant requirement that remain available to law enforcement in exigent circumstances, and the remedial implications for cases where location data was obtained without a warrant before the ruling established the new constitutional standard, are the legal details that will be worked through in the lower courts and in law enforcement practices in the months and years following the ruling, but whose broad direction the ruling has now established, in ways that meaningfully strengthen the constitutional protection for smartphone location data against warrantless government access, and that represent a significant development in the ongoing effort to apply the Fourth Amendment's protection against unreasonable searches to the digital surveillance capabilities that modern technology has made available. The practical implications of the Supreme Court's ruling for ordinary smartphone users, the specific ways in which the ruling changes what government can and cannot do with their location data, what protection they now have against warrantless location surveillance, and what legal framework now governs the relationship between their phone's location trail and law enforcement's interest in accessing it, are implications that deserve careful and honest communication. Because the ruling, however significant as a matter of constitutional law, does not eliminate all government access to location data or create absolute protection for the location trails that smartphones generate, but rather establishes procedural requirements for government access that provide meaningful protection while leaving important questions about the scope and the application of those requirements to be resolved through subsequent litigation and legislative action. The smartphone location trail that the Supreme Court's ruling addresses is a more comprehensive, more continuous, and more personally revealing record than most people who have never examined the location data on their own device or in their own app. Accounts have ever paused to consider, encompassing not just the approximate location records that wireless carriers maintain as a byproduct of their network operations, but the precise GPS-level location data that smartphone applications collect with the account holder's permission, the continuous location tracking that Android and iOS operating systems conduct as a background function of device operation, the location history that Google Maps and Apple Maps maintain as a record of every place the device has been with its owner, the location data embedded in photos taken with the device's camera that records the GPS coordinates of where each photo was taken, the Bluetooth and Wi-Fi positioning data that allows indoor location tracking with precision that GPS alone cannot achieve, and the location information generated by the growing ecosystem of connected services, loyalty programs, social media platforms, and commercial applications that collect location data as a component of their service delivery and that aggregate and, in many cases, sell that data to the commercial data brokers whose business model consists of assembling and monetizing the comprehensive location histories of millions of smartphone users. The specific settings changes that every smartphone user should make in response to the Supreme Court's ruling, the adjustments to their device's location. Settings, their application permissions, their account configurations, and their data retention settings that meaningfully reduce the location trail that their phone generates and stores in ways that are now more constitutionally protected from warrantless government access, but that remain exposed to the commercial data collection, the data broker aggregation, and the various non-governmental uses of location data that the Supreme Court's ruling does not address. Begin with a comprehensive audit of the location permissions that have been granted to every application on the device, because the most comprehensive and most precisely detailed location trail on most smartphones is generated not by the device's operating system itself, but by the applications that have been granted location permission, and that each independently collect, store, and in many cases transmit to remote servers the location data they are authorized to access. The location permission audit on Android devices requires navigating to the Settings application, finding the Location section within Privacy Settings, and examining both the list of applications that have been granted location permission and the specific level of permission each application holds, whether it has been granted precise location access rather than approximate location, whether it has been granted all the time background access rather than only while using the app access, and whether the specific justification for its location access level is clear and compelling given the application's stated function, revoking or downgrading location, permission for every application whose location access level cannot be justified by a specific and currently active function that the application performs for the user's benefit, and that requires the specific level of location, precision, and the specific background access frequency that has been granted. The location permission audit on iPhone devices follows a similar structure through the Settings application's Privacy and Security section and Location Services subsection, where the same categories of review and adjustment are available to iPhone users who want to meaningfully reduce the location trail generated by their device's applications by revoking or restricting location access for applications that do not have a clear and compelling justification for the level of access they currently hold. The Google location history and Apple significant location settings, the platform-level location tracking features that Google and Apple each maintain as part of their respective operating system and account services to provide location-aware features including personalized recommendations, travel history, and the various convenience functions that platform-level location awareness enables, represent another category of location trail that the Supreme Court's ruling makes more constitutionally protected from warrantless government access, but that remains a significant privacy consideration for users who value the confidentiality of their physical movement history and who have not previously reviewed or disabled these platform-level tracking features that operate alongside the application-level location permission system. The Google Location History Disable process requires accessing the Google account at myaccount.google.com, navigating to the Data and Privacy section, finding location history in the History settings, pausing the collection, and enabling auto-deletion for any historical location data that should not be retained, while also reviewing the Google Maps timeline to understand what location history has already been accumulated, and deleting specific entries, or clearing entire time periods of location history that represent unnecessary ongoing privacy exposure. Now that the Supreme Court's ruling has established constitutional protections for this category of data against warrantless government access, the Apple Significant Locations Disable process requires accessing iPhone settings, navigating to privacy and security, then location services, then system services, and finding the Significant Locations option that Apple uses to track frequently visited locations for personalized features, disabling this tracking and clearing the history of significant locations that has already been accumulated, reducing the platform-level location trail maintained by Apple's operating system services in addition to the application-level location trail addressed through the application permission audit, the photo location metadata setting, the device camera configuration that determines whether GPS coordinates are embedded in photos taken with the device as EXIF metadata that is invisible to the casual viewer but accessible to anyone who receives the photo and examines its metadata, providing the precise location where the photo was taken to recipients who may not be intended to receive that information, is a location privacy consideration whose management through the camera application's location settings provides an additional layer of control over the location data that the device generates and potentially shares beyond the user's awareness or intention. The commercial location data broker ecosystem, the network of companies whose business model consists of collecting smartphone location data from application companies, aggregating it across millions of users in extended time periods, and selling the resulting location intelligence to advertisers, insurers, hedge funds, law enforcement agencies, and any other purchaser willing to pay for access to the comprehensive location histories of individual smartphone users, is the dimension of the location data landscape that the Supreme Court's ruling most directly leaves unaddressed from a practical standpoint, because the ruling's constitutional protections operate against government access to location data through legal process, rather than against the commercial collection and commercial sale of location data that does not require any legal process, and that generates location trails whose comprehensiveness, whose historical depth, and whose commercial availability to any purchaser create privacy risks, whose mitigation requires the combination of the application permission management, the platform-level tracking disabling, and the data broker opt-out processes that together address the full spectrum of the location trail. Problem that the Supreme Court's ruling has now brought to the forefront of public attention in ways that make this the ideal moment to take comprehensive action across every dimension of smartphone location privacy, rather than limiting the response to the specific constitutional dimension that the ruling addresses. Turn off these location settings now. Conduct the comprehensive application permission audit on your device. Disable Google Location History in Apple. Significant locations. Adjust your camera's location metadata settings. Opt out of commercial location data collection wherever those opt-out mechanisms are available. And develop the ongoing location privacy management habits that treat your phone's location trail with the seriousness that the Supreme Court's recognition of its constitutional significance now confirms it deserves. Because the ruling that the highest court in the United States has just issued about your phone's location trail is not just a legal development of interest to lawyers and civil libertarians, but a direct signal to every smartphone user about the sensitivity, the significance, and the genuine privacy importance of the location data that their device generates continuously, and that the settings changes available to them right now can meaningfully protect from the full range of parties whose access to that location trail. The Supreme Court's ruling has now made the most constitutionally significant smartphone privacy issue in American law. Like this video, if this complete, legally informed, and practically actionable analysis of the Supreme Court's ruling on your phone's location trail and the specific settings you need to turn off in response gave you the legal understanding, the practical guidance, and the genuine motivation to take control of the location data that your smartphone has been generating about your life and whose constitutional significance the highest court in the land has now confirmed, demands the serious attention and the specific protective action that this video has described Subscribe to this channel for the kind of seriously researched, legally informed, and genuinely privacy protective content that empowers ordinary people to understand and respond to the legal and practical developments that shape the privacy of their digital lives in ways that matter for their safety, their freedom, and their fundamental right to move through the world without leaving behind a comprehensive digital trail whose access and whose use they have never meaningfully controlled. And tell me in the comments what location settings you are turning off first in response to the Supreme Court's ruling on your phone's location trail, and what aspect of this ruling you think is most significant for the future of smartphone privacy in America. See you in the next one.